And just so as long as one recording gets captured and shared, that'll do. So I'll leave it to you to record, and then to deliver the recording to.
Sure, I can send it to Jose.
Very good, perfect.
Great,
thank you.
Wonderful.
I'm sure this will be wonderful.
Thank you very much, Ben. Welcome, everyone. We really appreciate you joining us this afternoon or this morning, depending on where you find yourself today, to take time and join us for our panel on criminal justice and education reform, which will feature a comparative social equity policy analysis within the United States. Today, we have 5 panelists from Virginia Commonwealth University. Each of them are graduate students or recent graduates. And so I'm gonna let them each introduce themselves. We'll go Kamal, Anthony, and I'm trying to look alphabetically, Mary, Amidu, and Amidu and LaShae, right? If you'd like to introduce yourself.
Can you hear me? My name is Kamal Alhassan, and I'm in my second year of the PhD program at the L. Douglas Wilder School of Government and Public Affairs at the Virginia Commonwealth University. My interest is in the area of artificial intelligence, cybercrime, comparative law enforcement strategies and tactics, and social and racial equity. I'm happy to be here with you today. Thank you.
Anthony?
Everyone, can everyone hear me? Awesome. My name is Anthony Burley. I am a recent graduate of the L. Douglas Wilder School Master of Public Administration program. And my area of focus through undergrad and through graduate school has always been on social equity within the education, within the classroom. And you'll see a little bit of that later on. Thank you.
Hello, everyone. My name is Mary Elizabeth Doberneck. I'm also a recent graduate from the L. Douglas Wilder School of Government and Public Affairs here at VCU. My interests have focused a lot on policy analysis and interest in drug courts as well.
Hi, everyone. My name is Amidu, Kalokoh. I find myself in the second year of the PhD program in Public Policy and Administration and the L. Douglas Wilder School of Government and Public Affairs. My interest focuses on criminal justice and homeland security, as well as social equity issues and global and international security. Thank you.
Hello, everyone, and good afternoon. My name is LaShae Lambert. I graduated from Long Island University of Brooklyn with my MPA, and now I am at the VCU Wilder School getting my graduate certification for gender violence intervention. My area of research has always been sexual assault on college campuses and domestic violence and a survivor's road to recovery. Thank you.
Thank you to each of our panelists. We look forward to your presentations today. And so we'll go ahead and get started with the same order that we just went in. Each of our panelists have about a 7 to 8 minute presentation. And so what we'll do is, if you wouldn't mind reserving your questions until the end, or if you want to just put your question in the chat when we get to the Q&A section, I'll be sure to go through those questions, okay? So thanks again, and we'll get started here with Kamal. We can see your presentation. Great.
Okay. So having a little technical difficulty here, but that will be over soon. There you go. Okay, like I said, my name is Kamal Alhassan, and I'm in my second year of the PhD program. I'll be presenting a proposed research project on algorithmic risk assessment instruments in the criminal justice system and social equity. So the evolution of artificial intelligence, AI, has enabled both the private and public sector to develop a plethora of tools that sometimes break away from the traditional way of doing things. Public agencies are increasingly utilizing AI to assist with policy objectives and decision-making. And algorithmic tools are also now widely used across the criminal justice system today, such as predictive policing and predictive justice. Preliminary research suggests better outcomes from the use of these tools within the criminal justice. For instance, a report by ProPublica revealed that Black defendants were 77% more likely to be assigned higher risk scores than their white defendants, while whites were misclassified as low risk with a ratio of 48 to 28%. This research proposal resolved the research question of why this tool seems to favor white Americans. Why is this important? The 2003 Futures Report, Divided We Fall, states that government at all levels are in part responsible for many of the glaring inequalities we see today and should therefore lead the way to solutions. Public policies adopted over time at the federal, state, and local levels have created and exacerbated many of the inequalities that our communities are struggling with today. Further, the opaqueness of these systems due to copyright and trade secret concerns, and also the nature of the beast, just the way artificial intelligence work, is further evidence that such a study is necessary to promote some form of regulation or oversight. And the need for criminal justice reform, especially at this time, cannot be overstated. Over the years, efforts have been made to reform our criminal justice system. And this is as a recognition of the inherent bias of the system. The decriminalization of marijuana, for instance, is such an effort in this direction because of the disproportionate arrest of people of color. Therefore, a study such as this one is necessary to avoid eroding the progress that has been made so far. My research will be guided by the concept social equity, as it will help explore how social-cultural, social-political, and economic forces have helped create inequities in our society. This will highlight the concepts and paradigms that are sometimes erroneously used in developing these risk assessment instruments without regard to inequities. The themes covered in the definition of these concepts of social equity is the one offered by the Standing Panel on the Social Equity and Governance, and also by Johnson and Savara, which includes concepts such as equitable management of institutions and public services, reduction of inequality and injustice, promotion of greater equality, procedural fairness, and social outcomes. This will serve as the elevation for the research and help explain how AI risk assessment instruments may continue to perpetuate bias in our societies. There are three main systems in use today, which are the correctional offender management profiling for alternative sanctions, the public safety assessment, and the level of service inventory. States sometimes adopt a unique version of either one, but my focus is on Compass because of its widespread use and its accolade as the most advanced among these two. The use of AI, in spite of its potential for racial discrimination, is problematic and has raised concerns among members of the public and Congress because our constitutional framework in its current state is not capable of dealing with the biases of AI. Yet, without paying attention to the effects of slavery, racism, the inherent bias of the criminal justice system, an algorithmic risk assessment instrument will only reproduce for us a reflection of our society's bias disguised as artificial intelligence. These instruments assess factors such as the criminal involvement of defendants or their family and friends, their housing and employment stability. Therefore, the basic data that underlies a prediction has been described by some as proxies for African Americans due to the legacy of slavery, Jim Crow, discriminatory employment and housing practices, discriminatory crime policies, war on drugs, stop and frisk, three strike laws, etc. And as alluded to today by Congresswoman Frederica Wilson, If you know any Black family with a clean record, you should email her. There's also a desire to exaggerate the advancement of AI when developers are seeking financial support for their products. Most claims made by these developers are not corroborated by measurable empirical evidence or any academic research. This presents a conundrum when it comes to quantifying the benefits and impact of artificial intelligence on decision-making from a policy perspective. In 2013, Eric Loomis was found driving a car in Broward County that had been used in a shooting. He was arrested, but only pleaded guilty to looting an officer. In determining his sentence, the judge looked at his risk score assigned by Compass. The two classified Loomis as high risk of reoffending, and Loomis was sentenced to 6 years. He appealed the ruling on the grounds that the judge, in considering the outcome of an algorithm whose inner workings were secretive and could not be examined, violated due process. The Wisconsin Supreme Court held that the trial court's use of an algorithmic risk assessment instrument in sentencing did not violate the defendant's due process rights, even though the methodology used to produce assessment was disclosed neither to the court nor the defendant. The Supreme Court's decision to uphold the use of artificial intelligence tools effectively places obstacles in the path of civil rights for African Americans. This and similar court decisions in many respects effectively narrows the field of discrimination to only an express intent of discrimination. This study will use a qualitative research design approach for collecting and analyzing non-quantitative data. This approach is suitable for this study due to its flexibility in adapting data collection and analyzing techniques as new patterns emerge. In order to review the underlying set of rules of the Compass tool and interrogate the factors by Compass, compute risk scores for defendants, this study will be seeking documents and artifacts comprising the Compass questionnaire, manuals, risk scores, organizational promotional materials, letters, newspaper accounts, and other publicly available records of Compass, scholarly articles, and other articles from selected studies, and opinions will be sought. Preliminary implications and recommendations for this study. As alluded to by earlier research, this proposal would help determine if there's a need to provide social equity training for algorithmic developers and to implement this as part of the system development lifecycle. This will also encourage developers to adopt explainable AI methodologies, which is systems that can explain their rationale to a human user. It will also encourage the use of unbiased data through the cleaning or weighing of scores by applying social equity principles and involving major stakeholders in the implementation of AI systems, and will also help bring administrative oversight in a manner analogous to consumer and safety testing process used for physical products. This report will contribute to the literature in understanding that discrimination or indiscriminate use of these tools in our judicial system. These are some of the definitions in the paper and my references. Thank you, and that's the concluding part of my presentation.
Thank you very much, Kamal. We really appreciate it and look forward to speaking with you further about your research design for this project. Do you mind stop sharing your screen? So if you have any questions for Kamal, if you'd like to jot those down in the chat, I'll be sure to monitor those and we can bring them up a little later. We're going to go ahead and go on to our second panelist, which is Anthony Burley. And I'm going to pin Anthony. We see your screen, Anthony. You're all set. Looks great.
Can everyone hear me? Awesome. Hope everyone's having a lovely Friday. Once again, my name is Anthony Burley, recent graduate of the L. Douglas Wilder School with a Master's in Public Administration. And today I'll be talking about analysis of California charter school policy and federal charter school policy, analyzing that and seeing the positives, the negatives, and what is left to discuss. So quick introduction to the policies that we'll be talking about. There's the federal charter school policy, which is just the framework that all states follow. It dictates the kind of the do's and don'ts at a federal level for charter schools, and talks about things, how charter schools set up, how they receive funds. And then we'll be focusing on a variety of California education codes, but mainly California Education Code Section 47601. And that is how schools in California, especially charter schools in California, are set up, how they receive funds from the federal government. So a quick social analysis of the California Education Code. Some things it does really well. It creates this identity of school choice, the idea that if a parent doesn't like the public school or the other charter schools in the area, they can find another one, whether it be in zone or out of zone. A lot of these charter schools are located in low-income communities. So as mentioned before, if a parent doesn't feel like their school's receiving enough funding or doesn't support the needs of their child, if they have an IEP or some type of learning disability, they can get those resources at a charter school. It allows for private organizations to create these schools. So you see this a lot with religious affiliated organizations like the Catholic Church. And it allegedly makes school more competitive. So the typical market idea of if there's a lot of things around one another that sell the same thing, the things that make the best of that one thing will outshine the rest. As time has gone on, there have been some major failures. It's been created massive loopholes. So charter schools are able to start and never open a single door, but receive large amounts of money. A lot of location overlap. So as I mentioned before, if you have too many things around, it's not the best. So if you have 7, 8, 9 charter schools within a mile radius, it gets really hectic. And we see this in places like Los Angeles. And little enforcement, lack of regulation. So California, interestingly enough, didn't even have an oversight committee for this until 2019. And they're so backed up, they said that they might say it might take up to 3 years for them to kind of file through everything. And this kind of leads into the state financial mismanagement, that the money, people don't know where the money's going, the money's missing, and there's no way for them to track it down. So from a federal level, what can be done? So this idea of community is really important, especially when we talk about schools. If you're going to put a learning center in a community, that community should be involved in it. Understand what financial mismanagement looks like, the red flags, and then a stricter framework for states. States are also known as the wild, wild west of charter schools. They are incredibly varied. They don't overlap at all. States like California and New York have completely different charter school laws and policies, making them have similar guidelines and rules to follow. And what California has done that a lot of states are starting to follow is the idea of possible moratoriums until states can kind of figure out the financial flow of things and the proper guidelines. Implications and recommendations. Creating more consistent policy. And when I say consistent, I mean both from a overall just a legal standpoint, but also from a social equity standpoint. The idea that you need to contact those who are at these schools every day, who are in these neighborhoods every day, and to understand that what they really need. Also, some things that we kind of have to, that are being implied, is that charter schools really aren't going anywhere. There's a lot of advocates who want to get rid of charter schools completely, but we kind of have to realize that they're here to stay because they keep popping up. And we have to understand, how can we work collaboratively to have collaborative policy? How can charter schools and public schools come together to figure it out? A great example of this is the KIPP charter school system that works directly with low-income students in public schools in DC. They allow public schools to get resources from them and get rid of the political context. And we'll mention this in the concluding slide, a little bit more about what's been, how this has grown into a much larger conversation outside of just the policy. So some gaps or main challenges. Like I said, guidelines, state and federal guidelines have no parallels almost, depending on, and it's very, the amount of strictness is different from state to state. Inclusivity. There's not a lot of inclusivity, whether it be with, especially with those who are LGBTQI+, and those who are historically oppressed communities. Those aren't really included in these talks about where the charter goes, how the origin starts. And CRT, as we know, CRT has become completely politicized. And this has really, really dampened any progress in the charter school movement. And it's now, charter schools are now creating CRT avoidance schools. So coming in the future, there's going to be a lot more conversation around what's allowed and what's not allowed in charter schools. And financially, The government gives out billions of dollars in grants to these charter schools. And in California alone, over $3 billion was mismanaged. So we have to figure out where it's going, how to efficiently get it there, how to effectively get it to our students. Here's some contact information for me.
Thank you very much, Anthony. Excellent presentation. We look forward to following up with you as well in just a little while during our Q&A session. So next we're going to have Mary.
Hello, everybody. Again, my name is Mary Elizabeth Doberneck. I'm a recent graduate from the L. Douglas Wilder School of Government and Public Affairs at Virginia Commonwealth University. I finished my Master's of Science in Criminal Justice. And today I'll be presenting a comparative policy analysis on drug legislation at the federal and state level. The United States has a long history of negative beliefs, thoughts, and attitudes about individuals of color. Racism can be expressed not only by an individual, but by an institution as well. And one of the biggest examples of an institution with observable structural racism is the criminal justice system. American drug policies have a long history of being put in place to target the individuals who were associated with their usage. Early United States drug laws were formed from racist stereotypes and fears about negative habits of immigrants. This is particularly seen with the war on drugs, a system of social control that disproportionately targeted low-income Black American and Latinx citizens. Crack was introduced in the 1980s as a freebase version of cocaine. Crack cocaine use expanded quickly, one reason for its lesser street value compared to powder cocaine, and another because of its much more addictive properties. The qualities and price of crack allowed it to spread through low-income, predominantly Black American neighborhoods. It took little skill or experience to make money off of selling crack, and because of the addictive properties that had customers coming back for more and more, small-time drug dealers became increasingly violent in order to protect their economic boundaries from other drug dealers. The increase of crack and the violence surrounding it was met with the tough on crime era and the war on drugs, which lasted over 4 decades and fueled a historic incarceration boom. Crack was met with much harsher punishments compared to powder cocaine. Crack was met with a 5-year mandatory minimum with simple possession, while a cocaine user would need to be in possession of 100 times more than the crack user to receive the same sentence. This became popularly known as the 100-to-1 disparity. In the early 2000s, more attention was brought to the racist themes regarding disparities and harshness pertaining to crack and powder cocaine. Civil rights groups such as the American Civil Liberties Union and the Sentencing Project began urging for the decrease or elimination of differential treatment in regards to crack and powder cocaine. In 2010, an estimated 79% of federal crack cocaine defendants were Black Americans. On the contrary, an estimated 2/3 of all crack cocaine users were white or Hispanic, and surveys suggest that the users of said demographics typically purchase their drugs from those of the same ethnic and racial backgrounds. 2010 was an important year as Congress passed historic legislation repealing the mandatory minimum sentences for crack users and lowered the disparity of crack cocaine and powder cocaine sentencing from 100-to-1 to 18-to-1. This was known as the Fair Sentencing Act. This was the first congressional reform of sentencing laws in regards to the drug use in over 20 years, since the beginning of the war on drugs. Despite the Fair Sentencing Act being a step in the right direction for a more equitable criminal justice system, there are still limitations. The elimination of the mandatory 5-year minimum sentence for offenders is only for first-time offenders. Since so many Black Americans had already been affected by the crack cocaine legislation in place prior to the Fair Sentencing Act, they would not be considered first-time offenders. While this act may have seemed equitable and neutral in writing, its lack of specific retroactive language allotted for a large majority of the afflicted population to not reap the benefits of the act. The pervasiveness of disparities in drug crime sentencing and the overload of individuals falling susceptible to drug addiction provoked needed change in the criminal justice system. The response to this issue was the implementation of drug treatment courts. Virginia followed suit and implemented drug courts into their own government system. Presently in 2022, Virginia Code 18.2-254.1, the Drug Treatment Court Act, has allowed for multiple jurisdictions across the state to allow certain offenders the ability to be admitted into rehabilitative drug treatment programs, rather than dealing with their drug charges and the old business as usual model of conviction. The main goals of Virginia's drug treatment courts include to reduce drug addiction and drug dependency among offenders, to reduce recidivism, to reduce drug-related court workloads, to increase personal, familial, and societal accountability among the offenders, and to promote effective planning and use of resources among the criminal justice system and community agencies. Virginia allows offenders two types of ways to be admitted. First, if it is a first offense, offenders can enter a plea deal where they accept a guilty plea, enter into a drug treatment court, complete their rehabilitative program, and then their charges are dropped. Alternatively, individuals with a prior felony conviction may request to be moved to drug courts. This is particularly seen with probation violations that are typically due to an ongoing battle with addiction. This combats the equitable issues seen with the Fair Sentencing Act, as individuals with prior convictions or offenses from before the implementation of drug treatment courts may still have accessibility to the services the same way that first-time offenders may. These two acts seem to combat the inequities seen within the criminal justice system, stemming from the war on drugs. However, there are still gaps. The Fair Sentencing Act did not contain specific language that would make the legislation retroactive. Individuals charged before the act would not get to reap the benefits of it. They would not be considered first-time offenders, and that would not allow them the grace from the 5-year mandatory minimum sentencing. This is highly inequitable because it does not allow fair sentencing for all offenders, as it did not allow for offenders from before the date of the enactment to be sentenced under its guidelines as well. The Drug Treatment Court Act contains much more specific language than the Fair Sentencing Act. The language made sure to include that the state of Virginia has the right to deny access to drug treatment courts to anybody. As the legislation specifically highlights, by creating access to drug treatment courts in Virginia, they are not creating a right to treatment for every offender. This creates potential room for bias, as it allows for judges to ultimately make a yes or no decision on allowing offenders into drug treatment courts. Combating institutional racism is no easy task, especially within such a large organization such as the criminal justice system. The Fair Sentencing Act was a step in the right direction, but still lacked the important retroactive language that would help ensure equity for all offenders. Virginia's current policies surrounding the Drug Treatment Court Act include much more specific language. However, it leaves room for judges to ultimately make a yes or no decision based on their thoughts, feelings, and biases, and the fact that drug treatment courts are written to be a right, or a privilege, not a right. There is still much work to be done to truly ensure an equitable institution for all, but understanding the importance of language and how it can be interpreted in action is crucial for promoting equity within the criminal justice system. That concludes my presentation, and here's a list of references, my list of figures, and then finally, here's my contact information. Thank you all very much.
Thank you very much, Mary. So next we'll go to Amidu.
Yes.
Great.
Thank you very much. Okay. Yeah, do you all see my slides?
You're all set.
I'm presenting on mandatory minimum sentence in the United States, social equity analysis of federal and Virginia drug offenders. My name is Amidu Kalokoh. I'm in the public policy program in Virginia, Commonwealth University. The criminal justice system is meant to address criminal behavior by way of punishing perpetrators of criminal offenses through different means, one of which is mandatory minimum sentences. We realized that in the 1960s and 1970s, the United States decided to go tough on crime and declared a war on drug due to the interest in public safety. As criminal offenses were in the increase, they wanted to address this problem. And this led to different policies being enacted, including the 3 strikes and your outlaws. It led to unwarranted sentencing, leading to disproportionate impact on race and gender. Part of this problem was blamed on judicial discretion, which is the power that judges have to address cases before them based on circumstances and the evidence that came out of the trial. In order to address these discrepancies, the federal government decided to enact the Sentencing Reform Act of 1984, which established sentencing commission and further led to sentencing guidelines. This led to mandatory minimum sentences being drafted. Section 841 of the US Code, Title 21, specifically deals with mandatory minimum sentences, whereas the comparative policy, which is the Code of Virginia, subsection 18.12 to 12.1, deals with mandatory minimum punishment. The policy has so far advances social equity issues. One of these is unjustified sentencing, which it addresses as one of its primary aims and objectives. It looks into the differences in sentences between racial groups and gender, and addresses this problem by trying to create a minimum sentencing policy. It also addresses truth in sentencing, which was a problem before the policy was enacted. There was evidence that between racial groups, there was differences in the number of years served by sentences. Whites were reported to have served less than 80% of their jail terms, while minority groups, especially Blacks and Hispanics, served more than 90% of their jail terms. This led to public concerns, leading to this policy being important in addressing some of these differences in the criminal justice system. However, there are some failures as well. There has been increase in incarceration rate, prison population, and socioeconomic costs. For example, between 1980 and 2020, there was a 222% prison population growth. And by September 2016, there was a 49.1% drug offenders across the United States, of which 72% of these were convicted of mandatory minimums. As a continuation of evidence, for example, between racial groups, we realized that Blacks constituted 56.9% of mandatory minimum sentences, while Hispanics constituted 48.6%, the white constituted 43.7%, whilst other ethnic groups made up 41.9% of mandatory minimum sentences under drug laws within the United States. For policy solution, there was evidence that the policy has some problems, creating some discrepancies between racial groups and also gender. To address these differences, the federal safety valve as a provision was enacted by the federal government in order to reduce the impact of mandatory minimum sentences across the United States. In order for convicted individuals to benefit from this provision, they had to meet certain criteria, including their criminal history, which must not be bad to an extent that it undermines their chances of benefiting from this policy. Firearm and also violence must not have been used during the commission of the crime, and also death must not have occurred during this situation when the crime is committed. Their role also within the commission of this crime was also a concern. They should not have been the leaders of or the architect of this crime, and also they fully cooperated during the investigations and the trial process. Another provision that also concerned with reducing the impact of mandatory minimum sentences was the substantial assistance provision, which is about looking into how convicted individuals cooperated with investigations leading to the arrest of other members being accused of drug offenses at the state and the federal level. There are challenges regardless of the importance of this policy. For example, just sentencing, which is one of the primary goals of the policy, has not been met, as there are differences in sentences. This also led to excessive uniformity in the idea of trying to ensure just sentencing across drug offenders. Equality before the law is also another problem. This is whereby a certain group of individuals, that is drug offenders, are subjected to mandatory minimum sentences, whilst others are subjected to judicial discretion, giving them maybe lesser sentences compared to drug offenders. There is continued racial and gender disparities amongst ethnic groups, as well as between men and women across the United States and Virginia. The way the drug offenses are also weighted also created some challenges and gaps within the application of the policy. We realized that crack cocaine, which is mostly used by minority individuals, especially Blacks and Hispanics, carried a higher sentence compared to powdered cocaine, which is mostly used by the influential, affluent people and the white majority. There is also excessive policing reported, by the police across the minority communities, leading to more cases being mapped out from these communities compared to communities of majority white population. To conclude, it is evident that the policy is controversial, with different groups of people calling for its eradication as well as reform because of the continued racial disparity and gender disparity as well as the socioeconomic consequences of the policy. It has actually reduced judicial discretion, thereby alleviating the blame on judges for the increase in disproportionality in sentences, but also contributed to excessive uniformity, whereby it creates a problem of disparate punishment. As for recommendations to the problems therein, racial and gender statements are very important. This could be likened to environmental impact statements, whereby federal agencies are required to do environmental impact assessment to reevaluate or do a pre-evaluation, to look into what would be the likely impact of environmental impact. This could be borrowed from that to look into how criminal policies may impact, social equity issues, especially race and gender. It may also lead to the formation of alternatives to incarceration and improve the lives of sentenced individuals. The policy may be also reviewed and amended, looking into drug cases, how they are weighted in terms of punishment, and also to address the problem of implicit bias in system bureaucrats, policing, and also the judicial system across the United States and Virginia. Thank you. I welcome your questions and comments. This is my contact.
Thank you very much, Amidu. We look forward to the Q&A a little later. And then our final presenter today is LaShae Lambert. Great, we can see it. You're set to go.
All right, hello and good afternoon, everyone. Again, my name is LaShae Lambert, and today I'm going to be discussing sex trafficking, foster care children, and the prevalence and role economic inequities plays. I just wanted to start this off with a trigger warning. While this is not going to go into any explicit details of sex trafficking of children, the subject matter can be upsetting. So if this is not something that you feel comfortable hearing about, I will take no offense if you have to leave the room. The prevalence of sex trafficking and female children. The most common form of human trafficking is pimp-controlled trafficking of females, and 40.69% of them are female children. Additionally, the Bureau of Justice Statistics reported that out of 2,065 sex trafficking cases that are currently under investigation, 40% of them involve exploitation of a minor. Research done by Twist and their colleagues discovered that 33% of victims that are surveyed have been kicked out of their homes or ran away from home. Being sold off by a parent. The results from a qualitative study discovered that 81% of parents that were using illicit drugs as form of currency to traffic their children. Additionally, the National Juvenile Prostitution Study noted that 12% of arrests from juveniles involved with prostitution were exploited by a family member or a friend. And another element of child sex trafficking is when a parent allows sex offenders to abuse their children in exchange for money, drugs, or a place to stay. Beyond a parent, children are also trafficked by friends that they meet on a chat line for support, and also through friends that are met from school. Foster care and the increased vulnerability. Between 50 and 80% of children that are sex trafficking survivors have been in the foster care system at some point in their lives. And unfortunately, in some of these instances, they are recruited right from the foster care home that they live in. It is known that traffickers often target vulnerable victims, and typically those who have a background of abuse and neglect and who are runaways or homeless. And essentially, it's people that they feel are not going to be missed and are already having a difficult time in life. This is where it creates the cyclical pattern, because those who are abused and neglected and experiencing homelessness are more likely to be survivors of sex trafficking, and that creates the cycle. Economic inequities. Experiencing homelessness is one of the significant factors that make adult women and female children alike more susceptible to engaging in survival sex. Survival sex is a term that refers to the selling or exchange of sex for food, money, drugs, or shelter. And 43% of the children who were sex trafficking survivors listed being worried about housing and food during their time of being trafficked as one of the significant factors of choosing to engage in survival sex. Now, I use the term choose loosely because a female child cannot choose to engage in sexual activities with an adult, but in some instances in their mind, they are actively choosing to do so, if that makes sense. Federal legislation that has been developed to rectify this issue. So the Preventing Sex Trafficking and Strengthening Families Act is federal legislation that focuses on reporting instances of sex trafficking, including sex trafficking data in the adoption and foster care reporting system, identifying information in regards to children who run away from foster care and what their increased risk is of becoming a sex trafficking victim. Other information that is collected is information on individual state efforts that are going on to provide specialized services, increasing information on children in foster care to prevent sex trafficking from occurring in the future, and establishing a national advisory committee on the sex trafficking of children and youth in the United States. It's important to note that this advisory board is to be a bipartisan effort and also include survivors of child sex trafficking to have their input on it from a survivor standpoint. State level legislation here in the Commonwealth of Virginia. In 2019, Governor then Ralph Northam approved and signed into legislation this piece to ensure that sex trafficking assessments were being done across the Commonwealth for any child who was engaged in a sex trafficking incident. It also allowed for Child Protective Services to remove the child from the home for up to 72 hours without requiring parental consent. Also, it stated that there must be an investigation done and documented for each case that's been reported to the police department. So some unintended consequences. For the state level legislation, HB 2597, it does promote the removal of children from the home without parental consent. Now, the idea behind doing so is if the child is being sex trafficked by a parent, then the parent is not going to willingly sign over for them to leave. So the CPS worker and police can take them to help protect the child. Unfortunately, Black children are disproportionately represented in the foster care system, which stems from a lack of cultural competency and combined with structural racism. And research has shown that individual biases within the child welfare system influence the decision-making process. And child welfare workers that have cultural bias end up perpetuating discriminatory behavior, which increases the likelihood that children within the Black community are going to be removed from their home. A way forward. As Minstrom suggested, racial analysis should be done at the beginning stage of all policymaking. Neither the federal or state level legislation addresses how cultural competency will be embedded into these pieces of legislation, which should be done. For the federal level, there should be mandates put into place to outline guidelines for the states to implement. We know that due to federalism, it's kind of difficult for a federal piece of legislation to conduct what states do across the board, but there should be something stronger than just a suggestion of having interventions for child survivors of sex trafficking. And lastly, policies regarding topics such as foster care, sexual assault, and abuse should be research-driven and person-centered. Here are some of the references for what I discussed and my contact information.
Thank you very much, Shay. Thank you to each of our presenters. Round of applause to each of our presenters. We now have about 15 minutes or so for Q&A. So if the presenters want to come back online in terms of their cameras, please feel free to unmute yourself if you have a question, or if you would like to put your question in the chat, I'm happy to moderate that. But we really appreciate each of you being here today and look forward to your comments and questions. Shay, do you mind closing your sharing your screen? No, you're good. Great.
What is this button?
Wonderful.
Okay.
Heather.
Hello, everyone. I don't have a question. I just want to make a comment as a former alum myself, right? This last presentation was really caught my attention because I remember back in the summer, and please correct me if I'm wrong, last year, there was a young girl from Kentucky and her father brought her from Kentucky to Hampton Roads to sell her, right? I remember reading that. It was either Daily Press or the Virginia Pilot. And that just broke my heart to know here in the US, we still have, most people think of this as in other countries, but it happens here. So I'm glad that you brought that to attention. And it was also, I want to say kudos to everyone too, the AI, and as well, I think of weapons of math, MATH destruction, right? With the AI and social inequity. And with the drug and the war on drugs and inequalities there. Oh, if I could speak personally, and also I'm still working, on research in that area as well. So it's great to see you all doing this wonderful research.
I was choiring along with you, Heather, and I was on mute, so that wasn't very helpful, was it? Thank you very much. Hi, Harvey.
Hi, how are you?
Great to see you.
Wonderful. I've enjoyed these presentations immensely. Like Heather, I do work on AI. Part of that is criminal justice, but AI is much broader in terms of a possibility to both liberate us from labor and to make us more oppressed. So I think that's important. And Kamal, if you want to make a presentation on that again, I have a conference coming up next month in Africa. It's virtual, so shoot me an email. I enjoyed the presentation. You guys are wonderful. I'm just pleased to see such young talent doing research in these areas.
Thank you. Thank you very much, Professor White. Kamal, go ahead. I didn't mean to cut you off.
No, I was just saying thank you.
Sure. I'm very serious about the Africa piece, though. I'm talking about HI and its impact on Africa. And your piece fits nice with some of the stuff I'm doing there on a panel. But I'm going to put my email in the chat. If you're interested, shoot me an email. In general, I love to talk to you about your work. And same thing with the rest of you, if there's any way I can, be of assistance to young scholars, I'm always looking for people to replace me. And I'm so excited as I've moved to retirement. So wonderful. And thank you, Lindsey. Thank you, Heather. These are brilliant young scholars you're working with.
Telling the students, that my first presentation ever was at the Social Equity Conference in, I think, 2007. That was my first academic conference. And I was like, y'all, this is it. This is the one you got to go to, right? These are the nicest people you're ever going to meet. And Harvey, I'm pretty sure I met you there. So I appreciate all the mentoring and support that you all have provided over the years. And, glad to see you here today.
Well, I'm excited. This has been a wonderful conference, and virtual didn't stop us from doing what we need to do. So that's what's
absolutely important. I think it made it more accessible in a lot of ways too, right? Because everyone here got to come. I don't know if all 5 of these awesome students and graduates would have gotten to come otherwise. So
I know when I was a graduate student at VCU, I couldn't have afforded to go to any conferences.
Definitely not.
Well, barely can you do that.
We have about 10 more minutes. Are there other questions from the audience or from the panelists if you want to ask others questions as well?
I remember one of the PowerPoints that you had information about the drug court in Virginia. I remember, and I lived in Virginia at the time and was working with the Community Services Board. Well, I didn't work for the Community Services Board. Long story short, I had a job that was a criminal justice background type job, and drug courts were new at that time period. So it was really interesting. And we went to City Hall for one of the hearings in relation. And one of the biggest points that people had to bring home on a drug court again and again was that individuals with substance use disorder often relapse, and you cannot hold that against them, even if they're in drug court. You don't want to send them to jail when they relapse. So what are the statistics bearing out? I missed a little bit of that. I know you showed some numbers, I think, on.
I didn't have specific statistics on that, but it did say that offenders are able to petition to be entered into drug court and to kind of go through, like, if they do have a continuing battle with addiction and they continue to get charges, they still have the opportunity to stay in drug court.
I am curious, in Delaware, our governor just vetoed the legalization of marijuana. What's the status of that in Virginia?
I believe it's legal now. I think it's fully legal and not just kind of like decriminalized, if I'm not mistaken.
But the budget, they've just put a line into the budget. They legislate. Please help me, Anthony. I'm seeing you shaking your head. I'm trying to remember this.
Yeah, so marijuana recreationally, Dr. Evans was saying, they put a lot of vague policy into the budget regarding recreational marijuana. So technically speaking, it is legal. But this past February?
This last week.
Yeah.
In the budget, yeah.
Yeah, last week they put it in. And then this past, which was a big win because this past February, Republicans in the House had killed off a bill that would make it able to be limited, like a limited amount sold at a retail level. So right now there's a lot of talk around social equity and the idea of like who gets to be distributors of this of marijuana if it is allowed to be sold legally. But as of this moment, technically, very technically, it is allowed to be consumed recreationally.
Okay. So I find it interesting. I was having this conversation with some folks last week. So my understanding, and please correct me, anyone, because this is just hearsay, right? This is just conversation with friends, right? But DC went about it, legalizing it, but not approving vendors, right? So there's only like 6 vendors in all of DC that you can go and purchase, I think. But in Virginia, they kind of did it backwards, where they approved vendors, but they didn't legalize it. And so it's interesting in terms of a policy space, right? Which is where, you know, the presenters here today, where we all have been engaging for the last 6 months or so. It's interesting to see, like, oh, we messed up that time, so let's do it different. But they only pick and, you know, it's so rather than a broad view of thinking about policy holistically, it's like, well, we can't mess up that way, so we're just gonna completely flip it and just mess up the other way, right? So it's interesting in terms of an implementation and policy process for us as students and scholars in this space to kind of watch. And
well, now is the critical point too, when we start thinking about decriminalization and legalization across the various states. I'm up here in Maryland, everybody up in Baltimore. Anyway, when we think about it, here in Maryland, we've had medical for several years now. And now on the ballot coming up for referendum is recreational, right? So it's gonna be hard to see how that plays out. But you know, a couple of months ago, I might have my times wrong, but I attended something at the VCU Lunch and Learn, and it was KPMG that was there, right? And it really enlightened me here, because I didn't, here in Maryland, let me back up. Here in Maryland, there was some concern, legitimately so, over the vendors who were able to open up the shops, you know, as far as the medical marijuana places. And yeah, we already saw disparities there, so they have to address that, right? But I recall watching the KPMG piece and learning a little bit there and retooling that. I think it becomes critical that we don't allow a new system and a new market to be co-opted by the inequities that currently exist, like the big businesses. It'll never address what it was intended to, right? So that's just my opinion.
Yes, and I'd like to add that I think members of the Virginia Congress have sort of tried to put in a language where families that have been impacted by drug laws are given some type of priority or given some type of quota, but that's the language being debated on. But back to the question about the decriminalization of marijuana or the legalization of marijuana in Virginia, is still facing an uphill battle due to the current political dispensation. The current governor, I think, is trying to still punish marijuana possession when it's over the limit, as if it was still a Schedule 2 as a one substance. And so advocates are saying that that will bring us back to square one, because it's still going to be targeting certain minority populations.
You know, one step forward, two steps back, right? I feel like there's been a lot of panels over the last 3 days that, you know, use similar language to that. And that, you know, I think that's one of the things that we focused on this semester. Oh, it's going to kick us out in a second. And before it kicks us out, I want to thank each of you for coming in, because I've been cut off midstream in these for the last several days. And I want to get a picture. So if you all can smile, everybody on the screen, a smile, and I will get a screenshot. Okay, 3, 2, 1. Oh, you are great. Excellent. Wonderful. Thank you all so very much. Makes me happy. So I got a good picture, and it's going to be, you know, we're going to blast it out, y'all. We're real proud of you. So anyway, the students' contact information, or the presenters' contact information, is in the program book. If you weren't able to capture earlier and want to reach out to them, or if you are interested in connecting to others, I encourage you all to do it. Excellent job today, everybody. Great seeing you all, and look forward to what the future has in store.
Thank you.
Thank you.
Thank you.
Thank you.
Thanks, y'all. Really great job.
Can you email me that for the newsletter?
Yes, for SWAPA, done, and done. Yeah.
Thank you.
Okay, see ya.